Abuja Samre de that Lumba Honsen Semina, it's so enya say a chakra, and Yabobum for fluing. I say, I Timliga wife was say an idea, a year that Lumba, a year a real now, you know. Or I must say that Lumba, a real, and Sana, oh, now real now, you know. Sammy the Omo Timliga wife for any year, mammy, Akosua Serwaa, Sammy dear, and ye Omo Bussy ye, but almost Sammy the photocopy of the real. A woman holding din there. Sammy the Omo professor, Ombessing Akoko, not that Lumba Hons and Semono, or Masade in Semono, I call dying court, ama, just a court as Sanka Cotsanazo. And Sammy the almost say, won't they crow one dear? Ah, any evidence can see a power meeting me, a dinku, the say, Nomudi Kako coin in our court, Omudi Kako coin in our now on one, Nina, I say, Omudi Kuguacha say, Omanina, a who a tune to, and Sammy the almost say, oh, man, will wait, party. Document will be to me a boom. I might say, courts now, Mubabecono. Oh, meet me a quackudinkum. What a empty in Commonibi.
A kick in. So, Obikoye earlier, so you're part of me and this law 111. To Obikoye earlier, not to say, on the basis of law, no. Let's say, be a word, but only myself will send you a city, no. Kofo bebre na my information is a one here enko wi ase na wa o ka law no na nkofo bi kura ba be interpret is one kind of because it's like they be some for they be information for Friday eba tis almost say wo wa say ono abanche na say nya esijano so a momunya is almost wo wa send the eden a omo de so a other part, you know, almost on me because no normally there say where and when he say a LB Akosua, that is the law. Say when you are in a offer early, say offer maybe a fed probate. In so busy and you do another confirm one number because information
procedure say go in and out by it.
I'm patronti baby I'm no say me point now onim me say on a point of law no ye ba ha ye be camera no then am ran city am ran no say a ye be ka say a b ye be ka say b oh now on a point of law no say well wa yenkoye early say we ni wa in yekoye early say na be ya ye be use PND law 111 no e dey a check ejapade eni say yakoye early na so be say sell we wa say do an odi aba so the person other parties no so be challenge it no. So because I say we know I don't want to go into that argument because the information I was say about MI and Sakano. Who information and then I waste to say or channel waste to say and then I waste to say or channel waste to say there might be a like of progress in their cost. But from the point of law there, the way who's a sort of factory of the way you are who's a sort of factory of so that is how you should understand it. It's a hotel on I say now what the answer. Because one here that's a original information encophobic as well. Argument I think the information and too much. Too much. One should have who crap a womb. And the way say, or China way say, and the way say breaking news, or China way say. But as some of the anchor information about knowing your understanding, know how to do the analysis on the point of law. Now, on more almost sooner. Send a better China know when they go into that situation, they will know how to maneuver or how to go by it. But when the information I be Kasana be Timinya Bema made the point of law, yes.
I came purposely for you. Mr. adie na yesu mpese me bisa say appeal no process no say and a stages be na documents ni come and how long does it take for the appeal to be finalized?
Question ready. Okay, so over file appeal over didn't can file notice of appeal. So file notice of appeal notify court now with the assembly say over so file appeal till you have several other parties now till you several you have bosome miensa to file the substantive appeal and as appeal proper.
Okay,
but maybe within 3 months na say o hena say utumi apply to the court for extension till you grant extension na just say the amount of time would be file. But so one file for extension, I'm a young guarantee amount, I say 6 months trim appeal in trim.
Okay.
Indeed, so file for extension, I say a guarantee amount. Let's say file appeal proper. The court below no ever boa all the record of proceedings, any BBA, I give you a file appeal no washepo at the court of appeal. So the court of appeal, then now there are several parties now we are involved no. And you know, o file appeal no so I want now we are appellant no. They say they say mama Akosua Serwaa appeal obey the plaintiff appellant. Now odobo ni so ye defendant.
Okay.
And you know, so no setting out the grounds for appeal now. The best ever the parties involved. Then na court na fix it that or best atina or the assem no. I just gonna say appeal no. I na most not necessary say you best a court trial senior ye no high court no. I'll be free witnesses. I'm on my bar na ya be cross examine omo. Not necessary, sir. But when the need arises, then they can open that door for you. And you know, say parties near accept. Na say obia yin in samanwa. Obi okro objection or the beba. So all these processes na ebe koso. Say Akosua wie na say court near satisfy say obia kan your person kan. Na fi wa mama kwa mama fa alemo addresses. Now addresses no is either say court in the back say bia mumba me address court no orally. Just a lawyer's neighbor court no ma call address court no orally. And now say mum file mo written addresses. Into written addresses in there obetro no ja come court na court na ashe data or the bema judgment. So appeal no ebetuma very fast. Ebesumi to ache depending upon senior parties na you involved no how they are going to carry themselves up. Obu oha obetum the motion aba say ade we kura on tiase. Obu oha appeal na mu obetum the motion aba say yen strike out this record. Nyoma bebrebe to make pie film. And it's a way nyasa motion if any interlocutory motions. When you say motion that BBA Akosua smooth there, and there by a year or a year and a half there.
A year and a half. It's about a year and a half. Sister, you're fine. Wow. You're fine.
Untie, so when year matter in here court how.
Oh, really?
Yeah. Now there are present matters. Normally in some area in here court no. In some way of national interest. So it will be private matter. State talk hana ya kasa ho. Ba o call Ghana wa. Kofo bebre kura nim. Omo adwini ni so. Normally the political cases no. And na in PNP no. Na court no ya fast because in some bebre edit the court wa. Omunyan kakran kanwi.
Okay.
Depending upon send your money base account. Why you go between 2 years?
Hey.
But where the me my dream I make say my dream no 1 year the bedroom. 1 year the bedroom. 1 year the bedroom. Because any issue court in the importance because sir will be private matter.
Okay.
They will be private matter. Your issue court.
Sister Ifia, me dear no from 2017 to this day me go so kun on. Appeal 2017. Yeah, to this day. Sana mo ya no. Me me siblings we kun on dey word one.
Nti prestige. Mr. Wo mpacho. Nti bibi sa no ebetimi delay property.
Atare ka say ana.
Mpacho ai. Mia.
Only lawyers can see that you are the deal for fun ever. I know they do quack.
Na prestige me pacho ma me bisa me question me wie ye.
My question. Only answer no.
Mpacho nti sa no eba ni property sharing na ebetimi affect na na.
Ena na kamba be bisa nimpo.
Yes, definitely. I'm surprised to say Mama Akosua Serwaa ko file early and also quite appeal. So because there are 3 circumstances a bit to me about and are 3 outcomes. One, a bit to me about say ye bet G or Dobronia were any free in some. A bit to me cross about say court Becca say near High Court ne kind and no one no. A bit to me cross so about say Mama Akosua Serwaa na akra na be na why free in some. I'm a double the only surviving wife. A bit more banasa. Because the appeal court, no, the 3 justices, no, they're going to interpret the appeal based on merit and based on a point of law. To Omumu say Okrano, my lady during the cry, ayo, favor, or granto the customary marriage, now, me cry at same. So let's take it like say, young fan is say, Abia, Mama Akosua Serwaa na den appeal ko. At the end of the appeal, no, court ne say, or no crano, that customary marriage, no, na undeserve, ya jefinism. Nti ebasa na, sa letters of administration, no, say no, say, agantia man abeden. Because we call for letters of administration, because we are here. But say when you get it. Tafena ye go back, you could try letters of administration no na. Endu sa time so na ya ganti amount. Na say watch Japade na. And then afena ye go back, akwaji from Musema na. You see the confusion is going to happen. Tina me ye mo say obekwa appeal again tina o san ko file early. So in short no, say appeal in start pay. The issue about alien I was say hot because anything can happen. Because right now, no, although Bruni is also a co-wife, what if say a court of appeal can say the High Court kind of no.
Prestige and na metie wo omo the information cinema omo platforms and almost say appeal no omo kono yen say woman no sisi ana yen say occurred the marriage certificate never nemo or contest say or kotire say odobroni yen you realize say you no mo dia mo odobroni no odobroni be prove say you ampa. I don't know bibisa na no mo kam me na menti ase.
I was say appeal there are so many grounds over to me that's why appeal. Over to me ejina grounds cross say the judge erred on a fundamental error of law. Even for judge in the crown, one grounds could be said judge in the crown or interpret law with respect to evidence and fact. Yes.
Let me step in. It was me who said it. My trend, this is what I said. Listen there are 3 universal rules and there are 3 universal conditions that grounds of appeal as per Supreme Court error on the weight of the evidence against justice. Error on, just as you said, on the law and the evidence. But based on what Judge Dorinda said in her ruling as to the evidence at 136 and 137, there are 4 conditions that lawyers know wasn't for court, which has not been made public. Prestige, I promise you, if it is public, I will send it to you. It looks like, or outside, but they have a grounds of going to challenge Odoboni in marriage to that woman. And that is what I could say put me. We should have a they are going to challenge Odoboni ne marriage, not customary marriage, which was accepted because in their mind, they had no pictorial evidence. It was only one person who came and just suggested that Odoboni is married. And now Judge Dorinda objected. So that is it.
In fact, dear, that is a very fantastic way of analyzing it. You are damn right. You are right. I mean, you've analyzed the issue on a point of law. Dear Pacho 9, Mark 9, you've spoken more than a lawyer. 9. So you see how the appeal goes. So the way I appeal, Akosua, there are certain things you have to evoke and you have to see it. And yes, appeal and now appeal. If you miss those grounds now, dear, in fact, why are there? That's right, you are right. Who may say grounds now, dear, Akana, and no, you cannot go. But who you should say grounds now, there will be way I be to me and make it leeway. There are many grounds I will be so they are quite appeal. But the idea it fits into the grounds. Because what share case na course na me who any pair in Korean biawo some pair in Korean wa to have most nebe fundamental error of law. The judge did not apply the evidence with respect to facts. Those stuffs na send idea Tino young but when say miankasa no afena maybe analysis about ruling ankasa na ma hwe loopholes ewom na ma ba Akosua platform yi so na say ma to me bo na ma cheche obi ani nyina ehu the possible the strongest part of Akosua Serwaa mama Akosua Serwaa and the strongest part of Odoboni and the possible issues a bit may happen at in said the sports commentary no say sports connoisseurs no omo analysis hansa na ye ba be ye ti du okra na me hia na kodwene die mo na ma ba ne nyina ye analysis ni ahwe ye be gina mfimfin ye be on the point of law senior man tie se na be ya ye owotewa obehu bebia e be possible sa se na be tuma dey akọ so it will be interesting ti die 9 you see every judge is supposed to discharge those principles, and I can give you plethora of cases. I call Supreme Court, LA, those principles said for an appeal to succeed, those grounds must be met, and it should be a very strong grounds for you. And no. The weight of evidence.
Example of Akufo and Kathleen.
Oh yeah, and do you know that Akufo is one of the lawyers say lawyer or appeal no tako Supreme Court at the law school you cannot take away Akufo chachuchikata any Akufo lawyer no who any offense
remember I mentioned those names.
Akufo is the most referenced.
Exactly, you cannot take those people out. Sorry. And the end they will be a law school the history about Akufo Chikata Akutampa. And me, my favorite judge, Justice Ahmed Sule. Justice Ahmed Sule is one of my favorite judges.
Oh yes.
Now,
I don't know. Trainee. This that Atuguba and they came from the same because Ahmed Sule will tell you in your face the nonsense you did and school you. And trash your ruling. He's a more or less like Atuguba.
Yeah, now no okay, yeah. So you see, Atuguba senior is a senior to Ahmadu Sule. So it was Atuguba rather who nurtured Ahmadu Sule. Oh, so okay. Atuguba senior has now retired. So Ahmadu Sule, So Ahmadu Sule no ni mate ne my lord Puamai any Justice Noli Colin the Crano or form in terms of rank than Ahmadu Sule. Ahmadu Sule senior kakra. Oh,
So Colony there, Akufo no promoting to Supreme Court.
exactly,
If not,
exactly.
Colony should be probably at the High Court. And at the
Oh,
if
yeah.
they go in further, we should have been around High Court.
Yeah, intino.
Yeah.
Once into Osha, intino. Amadi Sule me penasem. When you see when constitutional issues happens, that is when you see the prowess of the judges, because constitutional matters are mostly political. So it was this was a judge who told my lady Isabato Kunu, the former chief justice, and the other panel said they are ruling on the injunction to enjoin the Speaker of Parliament, any parliament, from proceeding with the 4 vacant seats, was an aberration of justice. So for a judge to say his colleagues are engaged in an aberration, let us say, and ocean dissenting opinion, on a point of honor, my kind of bear 10 times. It was so marvelous. Amadi Sule. There are moments in which you fan of I think market versus the Speaker of Parliament 2024. And my friend Markin at the court, Supreme Court said the Speaker cannot declare the seat vacant. Constitutional issues.
Yes.
But at that time, he was the only judge who was able to tell the colleagues what they've done is an aberration. Now, I don't want to single him out, but judges now, most of them are very good. In Tosha appeal now, I think we have a lot to learn. Information
Proceed, I promise you, by Monday, if the green light, proceed, by Monday, if the green light is given and if documents are shared, I promise you, I'll get you a copy. I'll get you a copy.
Because who say, the legal mind never church here. Because I know, say, Odobroni will case, Mama Akosua Serwaa was no case. But me share me who say my lady Dorenda no judgment not the mine no. Okay, but me name grounds or multiple appeal. In this is any na you bet my analysis no. Me should be asem no person na ebe mo mutie no. Obi understand the beauty of the law. Lord, you already at the pa. Oh,
there's one thing that I think I want you to establish there. Pocho, let people know that the case file that is being sent to the appeals court, they are not going to ask them to come with an authentic source, or authenticated document. They are actually going to review the document that was brought in, and then evidence. They are going to talk about evidence and law, and they are going to base their argument based on the evidence at 136, 137. And see, people are saying, "Oh, you are panicking because the appeals court will allow them to bring in fresh evidence." And I also stated there 4 reasons why a fresh evidence will be allowed to pass or be admissible. At the time now, what your case, the document or the evidence wasn't available. They couldn't retrieve it, and they told the court, though, the manner that the magnitude of the evidence will have an adverse effect on the outcome. The 4th one, I'm really free. But people are making it there. It is just easy for anybody to submit a fresh evidence when these criteria are met. And what is the criteria? First of all, before the case was held, during the case management conference, they pointed out to them the errors in the purported document as marriage certificate. Judge Dorinda gave them the opportunity to bring it. They brought 3 separate documents, which they suggested as marriage certificate. Again, they couldn't prompt the court or the bench to say that, my lord, when we went for authentication, they have given us a month or 2 to come for the result. Therefore, please hold on. When we are ready with it, we'll submit it to court. None of these issues came up. So Judge Dorinda, just as we said, ruled this case based on technicalities. She didn't actually go into the nitty-gritties of the case. She ruled on technicalities that you could not provide an authentic certified marriage certificate. Therefore, you cannot come and tell me in my court there you contracted an ordinance marriage. The conditions were not met. Others are arguing there, oh, they will allow them to bring in a fresh document because it is possible, it is allowed. And I told them, based on the, aside from the universal rule that is there, the 4 conditions, I've forgotten the fourth one, correct? You can chip in. Based on what you have seen about this case, proceed, be honest with all of us. Do you think they will allow them to submit fresh evidence? And I also referenced 2 cases. The one that was in 2013, I think it happened in Malaysia, about the map of a land. I forgot the case. And then the one between, is it Vodafone Ghana and then somebody about a land dispute, where at the time they couldn't retrieve the document from the Lands Commission. I think it was between Lands Commission and somebody. They couldn't, that was in 2021. They couldn't retrieve the document from the Lands Commission, and the court was made aware. So at the appeals court, they allowed them to submit this fresh evidence, which overturned the ruling from the High Court. Please tell us, do you see any case or any reason why the appeals court will allow fresh evidence from this case?
But let's get this principle straight. So as you said it, the fundamental grounds are also convince the law lots, the 3 law lots at the Court of Appeal, in order for them to allow you to admit the fresh evidence. And I wouldn't boss. Say you must convince them. Say at the time now try no cost you took diligent steps to procure or to obtain those documents, but on San Intumianka, and on the basis of that, Nintino, Intumiama one kawasem, ama went to me ending kunim. So that is a fundamental ground. Say was to me convince you. It's a fundamental ground. Because fresh evidence na ebano, it is either coming to help your case or it is coming to destroy your case. However, no, say when you mean lay that grounds na ma court no, anya convince her. Ebe ti say the court no e favor, because ye nyina ya kwakon ina obi a che na hoodin. Ina wo de wa hoɔden no entumi amboa, but wako baby ina wakoja ahoɔden foforo na opese wo de be fight me. It's a better now when you fair to the other party. So fundamentally you have to convince the law Lord say at the time na need no, you made diligent effort to procure those documents, but on sending to me anchor na sa document no kura mpono. Se koba sanka onsa kaye at the time na yedi asem na anke betuma asesa asem no. That is fundamental. That is what you should convince them. Into here the popular case of Moshi versus Bejina. That could remember a brief case we amamo. Now how interesting it is. And also a UK case of Lad versus Marshall. Court set out this principle say, in order for you to even talk about fresh evidence, no, you should be able to establish that fact. So let me say I heard this question. Whether or not Mama Akosua Serwaa can establish the fact that at the time na yedi asem no, she made, the word is reasonable, diligent effort to procure and to bring those documents to the attention of the court below. In an insa into mianka na sa document anka by mpa anka betuma ma onu kwaye the only surviving spouse na, because all these things is going to emanate from the reliefs no. Oh, relief no do koye no e wana obesate free nti yesu ade na ye besate free the nti okọ court ni reliefs no enumu na insem we nyina be pie free maba Court of Appeal no kra no say omo ba besate di asem na omehe ni nti okọ court any near court say or they are going to be in that scope. Intino mo mumisa ho say at the time of Mudi asem no on record no omo catch a judge and say omo finding it difficult to bring this document and or even omo catch a judge and say omo take this effort say omo person the document way back.
No.
No,
Lawyer Kusi said that he has the original. That if he has it in his office. Judge,
I'm asking this question.
Outside. No, not at all. No, not at all. No. The answer is no.
No, okay. Exactly what you say. So if the answer is no, then the question is, will you be able to establish that fact? In our paragraph 88 in so meaning na I will say lawyers no so mo can be for certificate who also mo. There are many grounds for appeal. If they can abandon that certificate issue and kebebo, because paragraph 88 it knocks out anything be a fast certificate to home, because the court was clear from the timer or dismiss the interlocutory injunction. The court was clear on your oshushe. In a ura trial no, she was also clear on your oshushe.
Let me read the 88 for people to hear.
Okay, read it.
88, the tendering of this.
Dear, me about answer be reading me ceremony me ma hakra 280. So the likes me sir 8.3 and kama me ceremony me empower tap likes because addition I use FDL ne procedure no on the was ngwa the me ceremony o me empower tap need to me sustain life na monto gift him from rules in me the rules in the doors o me dem hado on the normal question o mo doors me ceremony fa lion ni giraffe ne chameleon ne lizard ne fall from sir na mo follow page in my wife. Yeah, but you between to ask me that's it.
Okay, paragraph 88. The tendering of this marriage certificate was objected to by the learned counsel for the defendant. This objection had been raised during the hearing of the application of the interlocutory injunction on 28th of October 2025. The court rejected the document and advised counsel for the plaintiff to ensure that they complied with the requirement under the Evidence Act. It is therefore a surprise that the plaintiff did not comply with the requirement nearly a month later.
So, in tune say, I kind of clear say that was what the court was looking for. Tune say, me can say, me nan come here a year more case with moi. Anka, the moment my lady raises her no, and commit me great nasokra a delay case no. Initially, me copy injunction and farmer, man commit me suicide with unqua Ediama a yen basso. Because Anka, I'll go upstairs and challenge this ruling. Because that was what the court was looking for. Intino, and on you could have applied to the court, say, then court no amount time now, open so take steps, say, Eddie make sure, say, what to me as satisfy the Evidence Act in a court initiation. And the best now what the court no. So the court will be forced to.
From what happened, can we say there?
I'll go there. So the court will be forced to either deny you or to give you some time. So court no a denial, it will be a perfect grounds for appeal, or it will be a perfect grounds for sexual right. So court no in denial next or more timer. Then that means also court na a variation of one kasa ni initial order say opiso dia assembly. So copim time on sabe kasa certificate no court need to mean to aso. In effect no injunction na nka okakope initially no which may use harm on saka. Meaning the entire argument number to my 1 year. That is the first thing. But Osha ruling in Muswa, there is no evidence on record say or ye nyami king in a court in refuse ye. So that means near court ne kan kran one fine edwuma. You were not interested in that. Into no all corners or case who jina sa grants we so for certificate na say enunti me the certificate for bar. You're gonna find it very difficult to convince the judges based on paragraph 88. Because you were given the fair opportunity to discharge that and one discharge it. So for me, 88 it collapses their case. So they be my favorite page paragraph 88. Because it tells you what the court was looking for. And it tells you the idea of the court. And it tells you that the court also gave you a fair hearing. It also tells you that the court also gave you a fair understanding of what process you should pass through. So failure to do that, that's why you have slept on your rights. So you cannot use the Court of Appeal for the Court of Appeal to help you enforce on your right that you slept on, which you were aware. And the Court of Appeal, I'm afraid, will not do that. Even if in an unlikely event, say, allow crime and fresh evidence and I say certificate in the bar, then also the Brunei lawyers no more sorry. They should fight this to the Supreme Court, asking the court that it will not be fair to them. Then the court should also give them the time for them to interrogate that document. Then the basana yabe mini trial. Una odi aba no ba be chan that yabe to two ano. You need be on free baby on free and it is going to bring a whole lot of issues and it's going to open the floodgates. Tell me, can say that document that 88 say omega so much now so the new document about there, then there should be a fiercely, if the Court of Appeal admit or give them that, they should resist it fiercely, because I don't think it will be right.
Let me be a question back on some Etienne Prestige. Okay. Back when I mean Chassis to me beside now when you say when I'm not High Court the trial case in Akosua, say if there is a listener, the plaintiff did not challenge the case and he agreed there was no objections by challenging the like to or not so challenge really. Not a judge in the past ruling never was I into almost let me appeal the same case one challenge man judge in the said my main specific and this win so I think 115. Let me read you here where I'm so do warrior the lawyer could see anyway I will say under cross examination or G2 Muse or satisfy and answer BBC. But now an immediate to link only way more than more can it seems also a one you some challenge or double near worry. But at the trial court not the high court was it DW1 tendered in evidence of the photographs and was it 116 all exhibits admitted in evidence without any objections, and they were not contradicted by the plaintiff under cross-examination. Like, until now, a possible say, a dear one challenge I would G2 me baby, and no better to me a call. Aqua challenging or appeal court. That's my question.
Okay, this is a very good question. It could be yes and it could be no. The reason is this. It could be no because one challenge, so why are you coming here to challenge? Since I said they be a law, no, you have to always make sure say you are coming on a point of law. One challenge. Why are you coming here to challenge?
Sorry, Mama baby in it was a counter claim by Odobroni. In their counter claim, their second relief. So the appeal, I'm sensing that is where they are going to target. But not on the certificate, which, as you said in the paragraph 88, bed destroyer. Although Bruni made a counter claim with 3 reliefs, 3 pleadings, and 1 was rejected, and 2 and 3 were agreed, and the 2 was her a customer married to Daddy Lumba. I'm sure that is where they're going to hit.
I think it was withdrawn.
It was not withdrawn. Check paragraph 6 and check paragraph 164. Nothing was withdrawn. You see, in
withdrawn parts now, I've heard a lot of people, and I don't mean to cut you off. I've heard people say it was withdrawn, but it was not captured in the judgment.
Please, it is captured, Akosua.
Mr. Withdrawn, no, almost say it was withdrawn. Mr. Withdrawn, no, was not captured.
Was not captured. No, it is part of the I
am a broth na make kana want to me no can the same thing. Me say in the judgment no, I know when the judge say although when you withdraw the claims no, into you can the same thing. What I say?
I agree with you. I am telling paragraph 6 and paragraph 164. Nothing was withdrawn.
It's not captured.
Paragraph 6, that paragraph 6, the second relief is what they are going to hit on at the appeal. So, Monsieur.
Okay. I'm not going to worry.
Maybe proceed and I'm a boy and no answer. Okay.
Can you proceed?
Not to jump at 20 in effect, no. Mammy Honey Claire or question, Eugene, or question is saying.
I think I mentioned the same paragraph B.
Eugene, but I'm going to
okay. Priscilla Nawareno. It seems that Oma Akusi and challenge it. Ojitum, it was says it was not challenged and it was accepted, and as I say. But at the same time now, to link him say appeal that particular portion. So no means the idea
but to link him but
and my friends and when friends the other then the Oma back for your from and say be my new mudini but mean kind 116 on 9% be 1 say all exhibits were admitted in evidence without any objections and they were not contradicted by the plaintiff under cross-examination. So in this scenario, no, what would be the basis? Are there one challenge here, one objective, also will appeal the same case?
I say it could be yes or no. What I say now, the issue is yes, you can challenge. However, no, over challenge here, you're gonna have a minute chance of succeeding. You're gonna have a very small chance of succeeding, unless you say you'll be able to prove say at that time no saasem no ebaye no na you were not in the known of all the circumstances surrounding that issue no, so it couldn't give you the opportunity for you to challenge it. But I know kind of bad amount, but ubit may raise it. But the ebema na no kase pa ni say during the trial no one challenge it, when raise it, one can wasem. So it was admitted into evidence and the judge relied on it. So you cannot blame the judge for one kasa wo ineptitude. But what am I say?